everyone. Welcome back to the series on resolution of disputes in commercial contracts. In the last session, we had gone through certain aspects of Arbitration and Conciliation Act. We'll start today from where we had left the last time, and we'll look at the other aspects of the Arbitration and Conciliation Act. More particularly, we look at the power under Section 9 and Section 17 of the Arbitration Act for grant of interim measures, both by court and the Arbitral Tribunal. We'll also look at Section 34, which provides for recourse against an arbitral award. We'll again briefly touch Section 37, which talks about Appealable Orders, which provides remedy of appeal against certain orders of the tribunal as well as the courts. And then we'll move on to one of the raging debates in the arbitration arena, which is the debate concerning the seat of the arbitration and the exclusive jurisdiction clause. Starting from Section 9 and Section 17 of the Arbitration and Conciliation Act. Now the question is, what is the purpose of these two provisions? Now, as we already know that the Civil Procedure, Evidence Act and other procedure don't apply in cases of arbitration, and the tribunal is free to make its own procedure. So then the question comes, what happens in cases of any urgency where any party is seeking any interim or an urgent relief in any matter? Now this question again is answered through two sections, which again is Section 9 and Section 17. Now Section 9 talks about the powers of the court, and Section 17 talks about the powers of the arbitral tribunal. Now when you read both the sections, both the powers of both the court and the tribunal are identical. Thereby, anything which the court can do in terms of passing an interim order, similarly the same thing the tribunal is capable of under the scheme of the Arbitration Act. Now there are various things that can be done under both these provisions, which include grant of injunctions, appointment of receivers, securing of goods and other properties. So similarly, the whole concept under the CPC where you are seeking urgent reliefs can entirely be covered under these two sections. Now, apart from the grant of the relief by the courts and the tribunal, it is also important to look at when one can prefer a Section 9 or when one can prefer a Section 17, because the powers are identical. Now the Arbitration Act creates a distinction between them as to when one can be preferred and when the other can be. Now the law is clear that when the arbitral tribunal has not been constituted, you go before a court, because it is only logical that you cannot ask the arbitral tribunal for any interim measures when such arbitral tribunal does not exist. So therefore, you go before a court. Now practically speaking, the courts are very conscious of something, and that is that there has to be an intention to arbitrate. Now there have been instances in the past where parties have taken injunctions or taken interim release from the courts, and they have again went on to protract litigation or not initiate arbitration and taken the benefit order of the order or injunction granted by the court under Section 9. Now to basically take care of those cases, now the courts require you to show the intention that you have to arbitrate, and practically speaking the court will also see whether you have already invoked the arbitration agreement or not, whether you are taking active steps for constitution of the arbitral tribunal. Now if you are not doing any of these things, the court will simply not grant you any relief under Section 9. Now three quick points which we must remember insofar as the jurisdiction of court is concerned under Section 9, and that is, the statute prescribes that in case of an order under Section 9, the arbitration must commence within 90 days. The second and the important aspect is that the court, even during the continuance of an arbitration proceedings, can entertain an application for interim measures under section 9 if the remedy to the party under section 17 is not efficacious. And the third and the most important aspect is that the court would also have the power to grant interim measures after the passing of the award and before the award has been enforced. And again, it is so logical because as soon as an award is passed, the arbitral tribunal becomes functus officio, and it would only be the courts which would have the power and capacity to grant any interim measures in case one is required by the parties. Coming to section 34 of the Arbitration and Conciliation Act, from a practitioner's point of view, it is the most important provision in the entire Arbitration Act, and much of the practice of an arbitration is centered around interference by the courts in cases of an award which has been passed. Now, to all my younger colleagues, I always suggest that they go through a judgment which is authored by Justice Nariman, and that it was in Associate Builders. Now, that judgment in a very lucid manner looks at the entire scope of the Arbitration and Conciliation Act and how the law has progressed so far as interference by court in cases of an award is passed. Now, as a background, one must remember that this judgment was passed before the 2015 amendment to the arbitration had come in. And even after that amendment, there is another amendment which has recently come in, which is the 2019 amendment. However, irrespective, the 2015 amendment provided some clarifications to the ground of public policy, which I'll come to it later. But as a background to understanding section 34, the judgment by Justice Nariman is an absolute must. If we look at the scheme of section 34 of the Arbitration and Conciliation Act, the grounds for setting aside of award are provided under section 34 subclause 2A and subclause 2B, and the ground of patent illegality is again provided under 34 subclause 2A. Now, when you are reading, without going into the detail because of lack of time, when you are reading section 34, please understand that section 34 subclause 2A, the grounds contained therein, those are not considered with the merit, those don't consider the merits of the award. Now, the grounds provided therein talk about some incapacity of the party, notice not being received by one party. So those are grounds under formal law, and as such, while they hold for those grounds hold good for setting aside of an award, but they per se, again reiterating, don't go into the merits of the award. Now, so far as the merits of the award are concerned, the two other grounds which are provided under 34(2) subclause B and 34(2)A, those are concerning the merits of the award. Now, one of the interesting grounds under 2 subclause B is that the award is in conflict with the public policy, and 34(2)A, which says that there is patent illegality. Now, what do these terms mean when you say that the award particularly is in conflict with public policy, or there is patent illegality insofar as the award is concerned? Now, what happened is, as I was referring to the award of Justice Nariman, now Justice Nariman goes through the set of authorities, and he goes through how the courts have interpreted the ground of public policy, and he very lucidly says what the grounds will be insofar as interpretation of being in conflict of public policy is concerned. Interestingly, all the grounds which were identified by Justice Nariman in his judgment were later incorporated as an explanation to section 34 to clarify what an award being in conflict with public policy would mean. So therefore that judgment is very important to understand what the term being in conflict with public policy means. Similarly, the cases of the award being there being a patent illegality in the award. Again, this term has been looked at by Justice Nariman in his judgment, and it is very important that one must refer and read to that judgment. Now, without getting into the interpretation aspects of the terms used therein or the grounds therein, the fact is one must remember there are some basic principles which we must always remember, and that is that when a court is looking at an award under section 34, in that case the court is not acting as an appeal court. What the court is going to see while relying on the grounds provided therein, the courts will not reappreciate any evidence which has been looked at by the arbitrator, and only in the cases where it shocks the conscience of the court will the court want to travel into the evidence in a matter. Now, another very important aspect insofar as section 34 is concerned is the statutory timeline which is provided to prefer such application. Now, the statute says that you have to prefer such application within 90 days from passing of the award, and again a 30 days time has been granted if any satisfactory cause is shown as to not preferring of the application for setting aside of the award. Now, in case you are not able to prefer an application for setting aside of the award within 120 days, then in that cases you unfortunately have no remedy, because the courts have clearly held that there cannot be any condonation of the delay in beyond 120 days if the application is not so preferred, and thus the award will attain finality and there will be no such remedy to the party. So therefore it is an absolute must that when you get an award which has to be challenged and there are sufficient grounds there for the challenge, then you must ensure that the statutory timeline is rather met and there is no delay at least beyond the prescribed statutory timeline. Coming to the aspect of appealable orders, Section 37 of the Arbitration and Conciliation Act provides for appealable orders. Now, there are only few orders under the Act which are appealable. The orders which again are appealable are bifurcated in two categories. One set of orders is from the orders passed by the court under the Arbitration Act, and the other set is the orders passed by the Arbitral Tribunal under the Act. Now, so far as the orders of the court are concerned, now any order which is passed under section 8, 9 or 34, 8 is for reference of parties to arbitration, 9 is for providing of interim measures, and 34 is an application for setting aside of an award. Now, any of the orders, and more particularly in cases of section 8, it is any denial of for reference to arbitration. So any orders under these three categories are appealable and which can be appealed under section 37 of the Arbitration Act. Now, so far as the orders of the Arbitral Tribunal which are concerned, there are two orders in particular. One is order under section 16 and the other is order under section 17. Now, if you recall that orders section 16 is basically the section which provides for challenge to the competence of an arbitral tribunal. Now, if the tribunal accepts the challenge to its jurisdiction and it holds the view that it has no jurisdiction and it has exceeded the jurisdiction in the matter, now that is the moment when the reference terminates, and that order is appealable under section 37 of the code. Whereas if the arbitral tribunal rejects a challenge under section 16, that does not become an appellable order. Then any order for grant or non-grant of interim measures under section 17 are again appellable orders under the scheme of section 37 of the Arbitration Act. Coming to the implication of identification of seat in respect of an arbitration and the implication thereof. Now, in the Indus Mobile judgment in 2017, Justice Nariman takes a view that if there is a seat identified in respect of an arbitration, the seat, such clause identifying such seat will amount to an exclusive jurisdiction clause. Now, this position created some controversy, as the conventional wisdom insofar as the exclusive jurisdiction clauses say that the parties with their consent can only exclude the jurisdiction of a court which originally had jurisdiction, and no party can use an exclusive jurisdiction clause to confer jurisdiction on a court which originally did not. Now, how do you know whether a court has jurisdiction in a matter or not? Now, if you want to basically see if the court has a jurisdiction or not, you have to refer to section 16 to 21 of the CPC. Now, it was argued before Justice Nariman that the exclusive jurisdiction clause will have to take in account and will have to, at the time of interpretation of that exclusive jurisdiction clause, you will have to see if the court over which the seat is being identified has jurisdiction in terms of section 16 to 21 of the CPC. Because if the court otherwise does not have jurisdiction in terms of the CPC, then it cannot operate as an exclusive jurisdiction clause. However, Justice Nariman rejected that challenge and was of the view that in cases of arbitration, the identification of the seat is of the paramount importance, and it would basically, in respect of so far as the suit is concerned, the law under 16 to 21 may hold good to see if there is any connection with that court, or if that court is being conferred with the jurisdiction. However, the rule will not apply insofar as the case of arbitration is concerned. And the reasoning that Justice Nariman gave in that particular matter was that the arbitration is anchored at the seat of the arbitration, and therefore the courts at the seat of the arbitration must exercise jurisdiction so far as those arbitration proceedings are concerned, and therefore by necessary implication that will amount to an exclusive jurisdiction clause. Now, because of the interpretation that Justice Nariman arrives at, it is very important in practice that when an arbitration agreement is being drafted, the seat of the arbitration must be identified between the parties so as to confer jurisdiction upon the court, which is again convenient to both the parties. With this, I conclude my introduction to Arbitration and Conciliation Act, which in my opinion is the most efficient remedy for dispute resolution in commercial contracts. In the next session, we will look at the remedy of summary suits under the Code of Civil Procedure.